All right. Hey guys. Okay. So where we are with this one is this is obviously the Wallace against Lively case in Texas. Um, so Wallace requested the court compel Lively to sit for an additional deposition. He also requested leave to basically upload Lively's deposition from last year as rebuttal evidence. And that was to support their motion to for an order requiring Blake Lively to give another deposition. So Lively has responded to the deposition request generally. So this is a further filing basically to oppose the Wallace motion for leave to include Lively's deposition as rebuttal evidence. So we'll just go through this. Sorry, there's a storm in the UK today. After weeks and weeks and weeks of really hot weather, I woke up. Well, I was literally woken up to like really loud thunder and lightning and like such heavy rain. So it keeps distracting me. I love thunder and lightning. Although Mia is next to me and she doesn't like it, so bless her. Right. Okay. So this is from Lively's attorneys. It's an opposition to plaintiff's motion for leave to include rebuttal evidence with reply in support of their motion for order requiring Blake Lively to give a deposition. Plaintiffs Jed Wallace and Street Relations request leave to submit evidence with their reply, but failed to explain how that evidence is relevant to, much less supports, their motion for leave to take Miss Lively's deposition, or why it only occurred to them to do so in a reply brief. Now, this request, given that this is an additional response from Lively, this is very much, in my opinion, client-driven. Right? This is Lively saying, you make this go away, to her attorneys. This request is nothing more than a distraction from the inadequacy of the Wallace Party's motion seeking leave to depose Miss Lively, much like the inadequacy of their opposition motion to Miss Lively's fee motion. And I'm telling you now, right? If she only got $400,000 out of a request for $8 million in fees in the Wayfarer case, Jed Wallace will be over here now saying, look, she only got this in this case, right? She cannot seriously, with a straight face, be requesting between I think it's like $800,000 she's wanting in this case. Like they keep saying nearly $1 million. But I think the figure is somewhere around the $800,000 to $900,000. But still, absolutely ridiculous, given that in this case, Jed Wallace never sexually harassed her. I think this is such an abuse. And on that note, actually, on the last video, one of the comments I had actually was, why does Blake Lively keep saying, why does she keep highlighting Sarah in every filing when, we all know this now? I've got a PowerPoint video I will be doing on just that. So to answer that question in a bit more depth, because it's such a great question. I can't remember for the life of me who it was that asked. Their name would be so familiar if I saw it as well, because it's someone who is very active with my comments and my videos. But thank you for asking the question. I think it was so I'm going to be doing a video basically on the advantage to Lively of persistently, hammering home that, in her mind, she's being sued by a billionaire, or, the whole power struggle. So, yeah, thank you for that. I will be doing that probably over the weekend. because I have still got the Stephanie Jones stuff to get to. I've still got the Sarah Ritz case against Celeste Smith. Things are building up, but unfortunately we're on school holiday still until next week, so it's been really hard to find a quiet room to record things in my home. But I will catch up with stuff, especially as the kiddo is going back to school next week. Okay, let's continue though. Okay. The Wallace parties have nothing relevant to add to the record that they could not have included in their original motion. If anything, the Wallace parties should be moving to supplement the record to disclose that, as was confirmed through the public filing of previously undisclosed text messages and emails this week, their client gave false testimony about his own personal knowledge and activities in order to conceal his role as a digital campaign. In order to conceal his role in a digital campaign against Miss Lively. And they've quoted here, "Did you have any involvement in what came to be Exhibit 51, the Amanda Ghost website?" Mr. Cooley objects. Wallace, I did not. Okay. And then Exhibit... Oh, they're talking about what was filed in the Jones docket. Right, okay. If the court is going to permit... So this is a PR filing. If the court is going to permit Mr. Wallace to supplement the record, it should, at a minimum, also consider this evidence, which shows that the Wallace party's entire narrative is based on lies. I mean, is Lively aware that Rebel Wilson, unlike Lively, won her lawsuit against Amanda Ghost? Just saying. Now that the Wallace parties have submitted their reply in support of their motion to take Miss Lively's deposition, what is most notable is that what they have not done. The Wallace parties have never provided any legal authority for the purported notice of deposition they served on Miss Lively without leave of court. The Wallace parties also do not meaningfully contest that the deposition notice was intended to pressure Miss Lively to drop her claims. This request is merely a continuation of that pressure campaign, and despite their extended discussion of waiver principles, the Wallace parties cite no case permitting a party to seek discovery in opposition to a motion after the deadline to oppose that motion has already passed, much less months later with no explanation for the passage of time with no action. I mean, I do think, I don't think it's a good look when Lively is saying, well, you know, Wallace hasn't Wallace hasn't contested any claims that, you know, his motion, basically the deposition notice, was an attempt to pressure Lively into dropping her claims, when in the thread Lively's attorney said, if you continue with this, we will bring our entire arsenal of attorneys and bill you for their time. There's no court that would have allowed that anyway. I mean, sure, the attorneys can turn up, but if you're requesting attorney's fees, as we've just seen in the case against Wayfarer, you know, you're not going to be guaranteed all the reasonable, and turning up with, you know, dozens of attorneys is not reasonable or necessary, then you're not going to get those fees. So it's an empty threat. I'm already annoyed. But yeah, I expect Wallace to be, you know, run into the docket with the outcome of the fee motion against Wayfarer. Like the motion itself, the request is unsupported by law and is intended to spin a false public narrative about Miss Lively and her actions in this case. There's no need to spin anything about Lively and her actions in this case. We've all seen it for our own eyes. As Miss Lively highlighted in her opposition, the Wallace parties failed to request any discovery or a hearing relating to their liability for Miss Lively's fees in responding to her 47.1 motion. The Wallace parties contend that they asserted numerous threshold arguments precluding fee liability. but seem not to understand that their deadline to oppose liability for fees was also their deadline to seek discovery relating to their liability for fees, including any alleged malice by Miss Lively, as opposed to evidence relating to the amount of Miss Lively's fee award, which Miss Lively agrees will come at a later date. The Wallace party's silence as to facts outside the record in their opposition to Miss Lively's 47.1 motion was a concession that there were no disputed factual issues with respect to their fee liability for the court to resolve. All the evidence they now submit for the record is irrelevant to the resolution of the 47.1 motion and solely offered as rebuttal evidence to discrete counter-arguments made in Miss Lively's opposition. The Wallace parties failed to identify any new arguments or new issue raised in Miss Lively's opposition that warrant the submission of the proposed evidence, which they also failed to do in the meet and confer process in advance of this leave request. The Wallace parties point to two discrete portions of Miss Lively's opposition that they claim support their request. The Wallace parties claim that Miss Lively interjected references to her deposition in the SDNY action in her opposition, and that they seek to introduce emails between their counsel and Miss Lively's counsel to rebut the arguments Miss Lively made in an effort to counter the argument that Lively opposed the Wallace party's efforts to initiate discovery in this lawsuit. First, Miss Lively did not attempt to counter the argument that she opposed Wallace party's efforts to initiate discovery in this lawsuit, because that is not what the Wallace party's motion claimed. Miss Lively countered the argument that she blocked discovery in this lawsuit, which is what the Wallace parties had accused her of, as though she unilaterally withheld something to which the Wallace parties were entitled. Of course, Miss Lively opposed pre-motion to dismiss discovery because, as the court confirmed, the Wallace parties sued her in a court that did not even have personal jurisdiction over her. In other words, she took exactly the steps that the Wallace parties took in the SDNY action when they were in the same situation. Doing so did not make it Miss Lively's fault that the Wallace parties' complaint never proceeded to discovery in this case. The Wallace parties' new emails show exactly that. In other words, they confirm something that Miss Lively never disputed. With respect to the additional deposition excerpts, the Wallace party's 11th hour request to include lengthy excerpts of Miss Lively's deposition in the SDNY action is entirely improper. Indeed, the Wallace parties have had the deposition transcript for over a year and could have sought to include any relevant portions as evidence in support of their 47.1 opposition or their motion. They chose not to, either in their opposition or even in connection with their motion for leave to take Miss Lively's deposition. Now, for the first time, they seek to use the deposition excerpts in a reply brief. Their protestations that they were barred from doing so based on the protective order in the SDNY action ring hollow, considering that in filing Miss Lively's testimony and seeking to use it as part of their arguments now, they have now done what they claim they were unable to do before. Instead, the Wallace party's choice not to submit any excerpts from Miss Lively's deposition was understandable from their perspective because it does not help their malice argument at all. Miss Lively was asked by the Wallace party's counsel about her personal knowledge relating to the filing of the CRD complaint and answered those questions fully and in a manner inconsistent with her meeting the standard for malice, namely, showing that the publication was motivated by hatred or ill will towards the plaintiff or by a showing that the defendant lacked reasonable grounds for belief in the truth of the publication and therefore acted in reckless disregard of the plaintiff's rights. Given Miss Lively's testimony that she did not know who the Wallace parties were or what they had done until she learned about that from materials in this case, the Wallace parties cannot and do not explain how a second chance to ask the same questions that they wouldn't be asking the same questions. The Wallace parties cannot and do not explain how a second chance to ask the same questions would yield a different answer or how the evidence they seek would even support their opposition to fee liability in the first place. Their desire to probe the same topics in a second deposition is more easily explained by the strategic goal of pressuring Miss Lively with the threat of further discovery than by a genuine desire to develop the record. Finally, the cases relied on by the Wallace parties do not support the relief they seek. In 2 of the cases offered by the Wallace parties, the court had to decide whether it had discretion to consider the arguments or issues that were raised for the first time in a brief, not whether supplemental evidence could be submitted in support of a reply. In the other case, the Wallace parties cite, the court permitted the defendant to submit a served reply in response to a serious allegation that it had based a motion to transfer on misrepresentations to the court which was first presented in the plaintiff's opposition. This case presents no similar circumstance. Further, the breadth of testimony that the Wallace parties seek to introduce demonstrates the real motive underlying their request. Despite claiming that the proposed rebuttal evidence is narrowly tailored, the Wallace parties seek to have the court consider the entirety of Miss Lively's testimony in response to questioning from the Wallace parties' counsel in the SDNY action. There is no reasoning why the entire line of questioning would be necessary to respond to Miss Lively's arguments in the opposition. The Wallace parties' failure to identify any new arguments warranting submission of the evidence and the excessive amount of testimony that they seek to submit demonstrates that their real motive in submitting the evidence is to continue to generate press about Miss Lively. So there we go. You would never think from reading this that Laura Lee Prather used to be Jed Wallace's attorney. There is a genuine air of hostility. Now, to be fair, she's doing a job. She's representing Lively against Jed Wallace in this case. So, and you know, attorneys generally don't they don't hold sentimental feeling usually. That's just a fact. But yeah. Okay, so we'll just have to see. I think we're waiting now for the judge to make a decision on this, so hopefully it won't be too long. But yeah, that's it. It's definitely this filing has been initiated by Lively going, make it stop. So yeah. All right then, guys.